So good afternoon, everyone. Thank you for joining us today. I'm Hannah from the Bangor Public Library. I just wanted to say a quick hello and thank you all for being here on behalf of the library. We're very excited today to have John Hutchinson from the Maine Business, Science, and Technology Library at Fogler over at the University of Maine to talk about patents and trademarks for business owners. We are co-sponsoring this program today along with SCORE, a business mentoring program. And I think, Dan, did you want to say a few words about SCORE before we get started? You can go ahead and unmute yourself.
Yeah, just one moment.
There he is.
I have something for this. Sorry if I hear anything in the background. SCORE is a resource partner to Small Business Administration, helping clients at all stages of their business cycle from pre-start to exit. And we just wanted to say thank you to the Bangor Public Library for co-hosting this event with us today, and from John from UMaine as well. Thank you so much.
Great. So John, I think if you want to take it away,
Terrific.
Go ahead.
Well, like the slide says, I'm John Hutchinson. I'm the business librarian at the University of Maine, and I'm also a representative at the Patton and Trademark Resource Center therein. The Patton and Trademark Resource Center is located right here in Fogler Library at UMaine. I'm sitting inside the PTRC right now. And let's get started. Patents and trademarks. Okay. Taken together, both of them are administered by the United States Patent and Trademark Office, which is an agency of the United States Department of Commerce in Washington, D.C. Patents and trademarks are very different from each other, but they both offer important legal protections. They both involve what can be lengthy and expensive application processes. And this is an important point. They only extend rights to the 50 United States and territories. There's no such thing as a worldwide patent or a worldwide trademark. You need to apply to other countries separately. There is something called the European Patent Office, which makes it easier to apply to multiple countries if you need to get an European patent, but I won't be talking about that right now. And importantly for what I do, they can be helped greatly by a thorough search of the appropriate government databases. Okay, trademarks. The following slides, by the way, are drawn in part from the training materials presented by Jason Lott of USPTO from the last PTRC training seminar. A trademark identifies the source of goods or services. Your trademark distinguishes your product from the goods and services of another product on the market, and it can potentially provide legal protection for the brand. Your trademark identifies where your product comes from. Now, a trademark can be your company's brand name, it can be a slogan, it can be your logo, it can be a combination of those things. It can encompass colors. I'm sure we all know that the UPS truck, the big part of UPS is their brown color on the trucks and uniforms. We all know Netflix red. That's part of their trademark as well. It can be part of your packaging. It could be the shape of a container, such as the distinctive shape of a Pepsi or a Coca-Cola bottle. It can even be a series of musical notes, like the 3 notes that denote NBC, or the ding, 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 ding of Intel Inside that we've heard on Intel microprocessor. It has to be a distinguishing feature of a particular product. Now, a domain name registration provides a web address, but it's not a trademark. And the name of your business is not necessarily your trademark. It's the mark that distinguishes your product, something you're selling, or the service you're providing. Now, what trademarks are not? A trademark does not mean you legally own the word or the phrase. The trademark does not mean you can stop other people from using that word or that phrase. And a trademark does not mean people owe you money when they use it. A lot of erroneous portrayals in popular culture make it sound like that's what it does. A trademark means that you own that mark and as it pertains to identifying your product. Now, a very common question we get around here is, do I necessarily need a trademark lawyer? No, a lawyer is not required. But keeping in mind, applying for a trademark can be a very complex process. Trademarks are registrations with the US government that have legal ramifications. This is a legal agreement with legal ramifications. Now, lawyers can be expensive, true, but statistics show that legal assistance results in a quicker process with fewer complications. Now, there's something else, a concept called common law. Now, do you need to have a registered trademark? Not necessarily. If you use a trademark in commerce, if you just have a product of snack cakes and you put your trademark on the packaging of your snack cakes, that automatically creates something called common law rights for the geographical area you're in. And if your trademark has been in use for a long time, it can even potentially be used in court infringement cases. You can prove that you've been using this product in commerce and it's connected to your product, and it can create common law rights. It's even possible that common law rights can trump federal registration sometimes, depending on how long it's been in use and how prevalent it is. And this is something that surprises the most people of anything I ever tell them about. Anyone can use the TM symbol. You right now with your product on the market, you can put your name, put that superimposed TM at the end of it. The TM does not require federal registration. It does not bring federal protection with it. It just says that you're showing the world, hey, this is my trademark. This is what I use to identify my business or my service or my product. You use TM whenever you want to. Now, keep in mind, when you apply for a trademark, they only search other trademarks in their database. They don't check any other source. So it's up to you when you're applying. It's a good idea when you're applying for a trademark for your goods, you should check the local market or check the national market to see if there are other businesses that are using a similar mark for a similar product. Because as I said, you might infringe on someone else who has common law unregistered rights, and they could potentially beat you in court with that. A federal registered trademark doesn't necessarily have the right to boss around a lot of common law unregistered people. Now, you can also apply for a trademark to the state you're doing business in. If you think that your business is only going to be in the state you're in, you can apply to just have your trademark registered with the state. I have a screen cap here of the section of the Maine government site, the Bureau of Corporations, Elections and Commissions. And I have a link there. Oh, and by the way, I'll be sending Hannah a PDF version of this PowerPoint presentation, and she can distribute it to the people who signed up for this. So you'll have a PDF of this, and the links will be live in the PDF. You can check on them. State registrations tend to be a lot simpler, much less expensive, and much quicker than registering with the US Patent Office. Now, so with that said, if you have common law and you have state registrations, why should you get a trademark registered with the USPTO? Well, because the trademark is national. You'll be registered throughout the country, not just for one state or one narrow geographical area. Means if you bring legal action, you can bring your legal action through federal court. And this is the one that most big companies appreciate. Your trademark can be registered with the U.S. Customs and Border Protection Agency that helps prevent the importation of counterfeit knockoff products. It also means you can use the coveted R symbol in the circle. So when you have a circled R, that means you've been registered with the USPTO as a registered trademark. Do not use the circled R without an official registration. They find out, they always find out, and you get fined. And you're in a lot of trouble if you pretend you have a federal registered trademark and you're not. Okay. However, not every trademark is registrable. Not every trademark is enforceable. But a trademark must avoid confusion with other brands. That's what they check when you apply for a trademark. They just find out if your trademark is in the danger of being confused with another brand that's selling a similar product with a similar trademark. Now, you might, if you're doing a search to see if your snack cake is your trademark for your snack cake corporation is a unique trademark, you might just type in Hutchinson's snack cakes, and if there's no one else with exactly that name, or if it's if the trademark is even similar in Maine in name it can result in a rejection of your trademark. You should consider many variant spellings. If you're considering making marquee snack cakes, you have to also do a search, see if anybody else has marquee snack cakes with using this spelling of marquee or this spelling of marquee. You have to think about variant spellings and as many crazy variant spellings you can think of. Keep foreign translations in mind. If you name your product Sheep Incorporated, but there's another similar company called Mouton, that would be a problem because Mouton is French for sheep. They take that into account as well. Now, a bad trademark that was likely to be rejected should not be literally a descriptive trademark. Like if you have a suntan oil company and you call yourself Great Tan, that's literally descriptive. It's probably not distinctive enough. They're going to get rejected. But the name can be what the USPTO calls suggestive of the product. Like if you name your suntan oil Copper Tone, it suggests what the product is about. It gives your skin a tone of copper, a healthy tan. And Copper Tone, as we all know, is a registered trademark. Copper Tone, first registered in 1955. It suggests what the product is about, but they're not going to call themselves Great Suntan Oil Incorporated or Great Tan or something like that. It's just merely descriptive and it's not likely to be registered. The best thing to do, and this is something the USPTO actually recommends and encourages, come up with a random word or just pick a brand name that has nothing to do with your product. Like, okay, if you have a fruit company and you try to name it Apple Incorporated, yeah, that's going to get rejected. It's too obvious. It's not distinctive. However, what if you wanted to have a company called Apple and you made, say, computers? That's perfectly acceptable. You know, Apple Incorporated is a computer company, as we all know, and they're registered in 1979 and it's still going because it's arbitrary. I mean, the word Apple has nothing to do with computers, but it passed through because that's arbitrary and there's no likelihood of confusion and it's distinctive. Also, something else the USPTO encourages you to do, just invent a word, invent a nonsense word. Xerox doesn't mean anything. Xerox was pulled out of a hat by the founders of the company in 1952. We're going to call our photocopying company Xerox, and nonsensical invented words are really easy to trademark, and they're really encouraged by the USPTO. That's easy to go through the process with something like that. I know that my grandmother used to complain about all these made-up words that were in the grocery store. And little did she know the USPTO has been encouraging US made-up words for decades. Now, what about trademarking a family name? Like if I want to do Hutchinson Books or a geographical name like Orono Clothes. You might think that's obvious. It's perfectly fair. How about why can't I name things after my last name or just named after the area that I'm in? That may seem simple enough, but those are discouraged by the USPTO. And you might say, well, that's not fair. What about McDonald's? What about places like that? There are plenty of companies that name themselves after the last name of the founder or something like that, or the area they're in. The process of determining whether or not a surname or a geographic area is admissible to register trademark is very complicated and took up a huge chunk of our training when the last training session we had for PTRC people. I'm not going to go into detail now because there's a lot of detail. But for more information, you can certainly ask for help with PTRC or the Patton office. But in general, how did McDonald's get away with it? It's because the McDonald's people didn't try to register their trademark until they were huge, until they were very recognizable and very successful and very well known as a hamburger fast food joint. And then they registered, and that helped. That's not a sure thing, but that's in general, that was the biggest reason why they were able to register a last name. Now, a trademark is a combination. It's a matching of a word or a picture to a product. It's your trademark matched to the product. Now, two very similar trademarks can coexist if they represent different products. Now, we've all heard of Delta Faucets, heard of Delta Airlines, exactly the same corporate name, Delta, but they're allowed to coexist as trademarks because one's an airline and one's a faucet company. How about Dove and Dove ice cream bars and Dove soap? Very different products, but the same name. And so it's It's a matching. This is a trademark is just not the word Dove. It's a matching of Dove to an ice cream bar or Dove to a soap. That's the trademark. It's a matching of one name to one kind of product. There are also different classes. When you apply for a trademark, you need to select one or more classes of product or services. If you're registering a trademark for a restaurant, as you can see here, restaurants are type 43. That's class number 43. But as some restaurants do, okay, I want to sell t-shirts that have the name of the restaurant. I know Applebee's does that. You can buy a t-shirt or a hat that has Applebee's on the front. Well, that's the case, you need to register your trademark as a class 25 as well. And yes, the USPTO charges per class. You have to be careful what you register for. And if you're not completely sure that you are going to sell t-shirts with your restaurant, you probably don't want to register for a t-shirt or clothing class if you don't need to. Now, one thing is, as I already hinted at, you can certainly start using your mark in commerce and then apply for a trademark. That's what a lot of companies have done that. That's what McDonald's did. McDonald's been a trademark for a long time after they started selling burgers. But you can also, if you have a trademark in mind, you can also apply if you have an intent to use the trademark in the future. Either one can result in a successful trademark registration if you're already using it or if you have the intent to use it. Though there are two different application types, but it's the same basic application process. It's just two different types. Now, remember, if you come in here if you contact me as a Patent and Trademark Resource Center person, I can't help you fill out the application, and I can't say this is eligible, this is a good trademark or a bad trademark. The two parts of my job is I can relate official policy. I can walk you through trademark registration policy put down by the USPTO. I'll give you the party line about what they recommend. I have plenty of brochures and literature that I could send to you or give you about the process. That's what I can do. Now, when you file the application, you will most likely be asked to provide a specimen of the marks used in commerce. That's usually a sample of the packaging, the wrapping. If you're selling shirts, a sample of the shirt or a sample of the packaging or a picture of the packaging. You need to send that in as well. After the application, for me, this is probably the most interesting part. Okay, you send your application, it's examined. The examiner at the USPTO might, if they have a problem with it, or think that your application doesn't fill out right, or if they have problems with if your application isn't eligible, they might put forth an office action, which is just an objection to your application, and you and your lawyer would respond to it. If the examiner says, okay, now your application looks great, as far as I'm concerned, this is a good trademark, then it's called published for opposition. It's put in the official Trademark Gazette. People in the public can examine the Gazette, and if anybody in the public has a problem with your trademark, they can raise an objection, and they might, if they say, hey, that trademark looks like my trademark, so I'm gonna raise an objection to your trademark, and then there's a procedure for going through mediation, and they decide whether or not this is going to put a stop to your trademark or not. If you receive an official registration, you need to pay fees. Every few years, you send specimens to make sure you're still using the mark. You have to prove you're still using it. Use it or lose it. You have to be using your trademark for it to be a valid trademark. By the way, this is a random page out of the most recent Trademark Official Gazette. This is a trademark for some letter K. It's in class 16, which is clothes like shirts and socks. And so if you see that weird looking letter K somewhere in the market, you know that it was first published just this week. Now, longevity. This is the biggest difference between trademarks and patents. If you keep using that trademark and fill out the forms and make the payments, your trademark can live forever. It can go on for a long, long time. You've heard of Underwood Deviled Ham? It was first registered in 1868, still going. There it is. Most of us know the logo. There are even trademarks older than that, where if you just Underwood, there's no one alive on this earth who remembers firsthand about the registration of Underwood deviled ham, but it's still going after all these years. And a lot of trademarks are old like that. Now, anyone working with trademarks will tell you a search of existing trademarks is crucial. The database for the US trademarks is the Trademark Electronic Search System. I cannot do your search for you, but can I show you how it works? Well, the answer to that is a resounding yes. I'm highly trained in tests, and helping people learn it is a main function of my job. I'm going to, so a very brief, just so you can look and see what it looks like. Go out of here. Second here. Go to this. Can you still see the window? Good. Okay, great. This is the USPTO website, and they put it under Find It Fast. And here is tests, which is the official trademark database. They have three different levels of searching. There's for new users, structured, and free form. I'm going to bring up, before I do that, structured. I like this a lot. They have different codes for different kinds of pictures. If you bring up the design search code manual, look at this. They have different codes for different kinds of things you might see in a trademark. If you click on animals, if you're thinking about a trademark with a lion, that would be 030101. There's tigers. There's dogs. Dogs would be 030108. And there's bears, other than pandas or teddy bears. I'm going to copy that. In case you didn't catch it, I work at the University of Maine, so we're rather fond of bears up here. So I'm going to go to tests, go here, and if you do this, and I tell it, I want to look for the design code like that, submit, and there is a list of the 8,347 records that have bears. And if you click on image list, you can see all of them. Look at that. It's bears. See, to me, it looks like a fox, but somewhere there, someone at USPTO said that was a bear. There's another bear superhero, apparently. There's bears with barbells. And you can combine two different design codes. If you're wondering, if you're thinking about a trademark that has a bear and a flag, you could find the one for bear and find the design code for a flag and do a search and see how many things out there have a bear and a flag in it. And for any of those, you do a search again here. Let's look at the image list again. And just to show you what the record looks like, let's pick the superhero guy. Okay, this happens to be, this tells you information about it. This is, if you're thinking about using a bear as a superhero, you can. This one is registered as part of an air conditioning contractor, and they do drain cleaning and boilers. So if you're thinking about having a bear as a superhero for your snack cakes, possibly you're in good shape because they're two different products. So your bear superhero advertising snack cakes would not conflict with this one, because even though they're both bear superheroes, they're doing air conditioning repair and you're selling snack cakes. So it's not a trademark infringement. Always remember, it's not just the name, it's what the name is connected to. And let's go back to my presentation here. If you're wondering, and there, okay. Yeah, good. Okay, I'm going to stop for the next section is patents. So I'll take questions. How are we doing, Hannah?
Yeah, we have one in the chat from Christian about how about initials as a logo?
Sure. Absolutely. That happens all the time. That's just another function of letters. This will be interesting. Let me briefly see if there's a design code for letters. Let me go back to the test home, design and search, almost dwellings. Well, I'll tell you what, you can also do a design keyword search. Let's look for initials. So, no. Let's see if there's a subsection under letters. There's circles. There's I don't see one specifically for initials, but let's face it, initials are just letters. So you can have different letters or letters forming animals, letters forming objects, plants. You can see it gets very detailed sometimes. This is letters or words underlined and or overlined with one or more strokes or lines. Oblong. So really, I would say, in my uninformed opinion, I would say possibly, from what I can see, us PTRC people would say this a lot. Possibly, as far as I can see, in my capacity as not a lawyer, initials looks like they wouldn't be a problem. Yep.
And Kathleen's asking about the application fee. Is that $250 per classification? Is that
That's
right?
correct. Hey, someone's done some homework there. That's right. Yes. Mhm.
Excellent.
But I never like to quote prices specifically because the PTRC is an important facet of the USPTO nationally, but they aren't always good about informing us in a timely way about changes in policy like pricing. And it's possible, even if they do, that I might miss it. So the best way to really know about the pricing of application fees and things like that is to consult a website or a patent professional at the USPTO or a patent lawyer.
More questions about pricing that you just said you don't want to answer.
Well, maybe I can show you this section of the website, and I can put the
well,
link.
this one's just about if you did want to get a lawyer to help, do the search and submit the application. She's saying that she's heard it would probably be between $2,000 and $5,000, and wonders if if that's in the right ballpark.
I wouldn't be surprised.
Mhm.
That's why when you do the searching for yourself, and I recommend anybody should come to the PTRC and I can show them how to do a good search for themselves, because I know tests inside and out. That will do what's called a knockout search. That means that if you do a search, that's a good chance of finding out if you're playing around with a trademark that is not trademarkable, because someone else says exactly the same thing for exactly the same, not even exactly, but something that's basically the same as your trademark with basically the same product you're selling. As a librarian, it goes against my librarian logic, but you're helping someone do a search and they're hoping not to find something. But if you come in and do a knockout search, you're helping yourself so you're not paying a lawyer to do a search and then finding out, oh, I did the search and you owe me $2,000, and by the way, your trademark isn't going to work. Whereas if you come in and I help you how to do it, you'll find out your trademark isn't going to work, but at no cost to you, because I don't charge for anything. Now, don't get me wrong, the lawyer is still going to do a search. But if you do a search on your own, when you do a good search before you even see a lawyer or even use a lawyer, then you know that your trademark has a chance. As far as you can tell, and then the trademark lawyer will do a search, and trademark lawyers are insanely good at trademark searching. I'm very, very comfortable using tests, but they know tricks with the programming and chats that do things that are just beyond me, that involve specific like program lines and things to look for.
And then regarding the fees, are those
Yes.
annual or on a regular basis?
Those are every 10 years. And the fees go up and down depending on USPTO budgeting. They're not like patents, where patent, we'll talk about that. Their patents have maintenance fees too, and those are more predictable and more stable in their pricing than trademarks are. But that's every 10 years.
And there's a question from Amy. If a name you want to use is being used for a similar use, but in another state, should you still stay away from it?
Now this is just me as my understanding of it. If we're talking about common law, if you're not going to be selling in the same market as that, if you're not going to be selling your product in that state, you're probably fine if it's not in the same geographic area. If your trademark's never going to be seen in the same place as that other trademark, it's fine. However, if you're only selling your product in one geographic area and not throughout the country, you want to think about, do I really need to register a trademark if I'm never going to go outside of Maine? However, if you're applying for a trademark on a national basis, it's entirely possible that the trademark examiner will say, well, look, there's something very similar in in the next state over. And that looks to me like I want to disallow your trademark. Explain to me why that might not be. And you could have, and you and the trademark examiner and your lawyer can talk about whether or not that's a barrier for acceptance.
Mm-hmm. And I just had one more question, maybe to wrap up this section, and
Sure.
then obviously we'll have more questions again
Yeah,
at the end. But, I imagine that most of the folks on this call are small business owners, right?
Yeah.
Like, and it seems like a pretty involved process. And you did a nice job of highlighting some of the other options, aside
involved
from
is a
doing
kind way
full
of putting it, but
registration.
yeah.
Yeah. So, is this something that you think like most people on a small business scale, it's worth pursuing, or would it really only be, sort of what are the biggest advantages or the scenarios in which it would be really important to actually go through the full registration
biggest thing
process
is
versus
that,
some of those other options?
If you are going to be doing any selling internationally, even just if you're in Maine, even our next door neighbor, Canada, even if if there's anything international going on, that's one big advantage in trademarks, because then you can register your stuff with the U.S. Customs to make sure that nobody doing knockoffs or counterfeit versions are going to get through, because Customs checks for counterfeit and checks trademarks and checks for counterfeit goods coming over. If you're selling in the next state over, that might if you're selling in a large geographic area, especially multi-states, you might want to think about doing it to make sure your trademark is protected, and that it's not and there's no danger of after you register a trademark. See, the PTO is kind of saying, look, we just register. We're not going to help you enforce. We don't enforce. I'll talk about that in a minute, but we don't enforce the laws. We just take the applications and we provide the registration. That's not quite true, because if you have a registered trademark with the USPTO, it's kind of a passive protection, because let's say if I register Hutchinson books and someone else a year from now tries to register Hutchinson books, they'll say, oh, nope, you can't do that because John Hutchinson registered that trademark last year, so you can't have it. So it's kind of a passive. So it's the USPTO will prevent people from registering a trademark that's similar to yours. It doesn't have to be exact, in case I didn't make that clear. Just something, it could be slightly misspelled, or a similar sounding word, or a similar meaning word. I'll tell you really quick. I come from Bridgeton, Maine. It's a small town in Maine, over on the west, almost on the New Hampshire line. In Bridgeton, there's a McDonald's that sells burgers. We all know McDonald's, and there's also a McDonald Motors. McDonald Motors and McDonald's, they're very close to each other. McDonald Motors is a used car dealership. Do they sue each other for infringement? No, because McDonald makes restaurants, McDonald's makes burgers, McDonald Motors, they sell cars. So there's no need for clashing like that. However, if someone opened a burger joint that had a big M on the front and it was McDougal's Burgers, McDonald's probably would say, no, you can't do that. You have a big M and it's kind of sort of sounds like McDonald's and you're selling burgers, and they could sue, and they have every expectation they probably would have to force them not to do that. So when you register, it keeps people from even looking vaguely like you, like that. Does that make sense?
That's really helpful. Yeah,
Yes.
I think so. So let's forge ahead with patents, because I
Yes.
want to keep an eye on the clock, and we're trying to wrap up around 1. So we'll try to zip through the next section here.
Let's find out here. And from the side. Okay. Okay, I want to reiterate, I cannot give you legal advice about your patent, or I cannot judge whether your invention is patentable or help you with your application. That's a job for a patent attorney. I can give you free information about the patent PTO policy. I can show you how to do a patent search all day long on the official USP database. Now, what's a patent? A patent is it's a legal agreement. It gives you the right to exclude others from manufacturing or using or marketing or selling or offering for sale or importing an invention for a specific period of time. And A patent granting authority issues a patent to an inventor if your invention is novel, is useful, and not obvious. N-U-N, none. Novel, useful, non-obvious, and only in return. And in return, your patent has to be a complete, full public disclosure of how the invention is made. About expirations, the utility and plant, there are 3 different kinds. I'll go into that. I should have put this slide after the 3 types. I'm sorry. Utility and plant patents expire after 20 years. Design patents expire after 50 years. Utility patents can also expire if maintenance payments are not made at 3.5 years, 7.5 years, and 11.5 years. There are maintenance fees that have to be paid at 3.5, 7.5, 11.5 years. You cannot pay them ahead of time. You have to pay the maintenance fees at exactly at 3.5 years, another 7.5, another 11.5. Plant and design patents have no maintenance fees. You get the patent and you're fine. Okay, 3 kinds of patents. Utility patents are for a new and useful process, machine, article of manufacture, compositions of matters. This is what most people mean when they say the word patent, a patented invention. Most people view utility patents are the vast majority of patents are utility patents. They're processes, they're machines, there's something being produced by a machine. There are compositions like a new metal, a new material, new kind of fabric. A design patent is just kind of what it sounds like. It's just a design. It's an ornament. A good example is a hood ornament, or an action figure like toys. You can get a design patent, just a toy. That's just for ornamentation. It's just the really good example is a font, a typeface. Whether or not the word is in Arial or in New York or in any other font, it's the same word, and you can tell it's the same word, but they look different. That's a design patent. And a plant patent is for the discovery and invention of a new asexually reproducing plant. I'm not going to talk about those too much, but there are plant patents as well. All patents have 3 requirements. They must have at least one novel aspect. It must be something that is new. The whole invention doesn't need to be new, but it has to have one new aspect that you came up with. They must perform a function. This is called usefulness. They have to actually do something. This is a utility patent. It has to actually perform a function. And it must be non-obvious. It has to have sufficient difference from what has been used to describe before. If you have a patent, if your patent is for, instead of a 2-slice toaster, I have an 8-slice toaster. No, that's too obvious. Of course, anybody can think, yeah, a toaster would be better if you put more bread in it. But if you were designing a new kind of self-timing heating element that prevents toast from burning, that possibly might be patentable. And that's, if by obvious, it doesn't mean if it's some kind of mechanical thing, like for a car, like a new kind of fuel injection. It has to, if you're thinking of a new kind of fuel injector, it has to be not just not obvious to the average layman who doesn't know anything about cars. It has to be not obvious to someone who is an actual professional car mechanic. You have to think about, would this be an obvious change for the average car mechanic? Then it's too obvious. It has to be not, it has to be something creative. It has to be something that is not an obvious thing that anybody could think of, even if they haven't actually done it. About novelty, it has to be not exiting. This is an example of language that the USPTO uses that no one else does. Anything not existing in what is called the prior art. Prior art is any evidence that your invention has already been thought of. Prior art is anything that's come before. Now, this is important. Prior art does not have to be an invention that actually exists. It doesn't have to be something that's even commercially available anymore. It's enough that if someone somewhere sometime has described or shown something or made something that contains a use of technology that's similar to yours, that counts as prior art. It can be a prehistoric cave painting. If you design something, your design patent, but there's a prehistoric cave painting that looks too much like your cave painting, then your design, you can be disqualified. Even if the cave painting is 140,000 years ago and they never got patented, that still counts as prior art. And anything really what's in prior art, no matter how long ago, if it looks too much like your invention, that can be a problem. And this is a good list from my colleague Sarah Walton. Prior art, anything published, patent applications, thesis, journal, magazine articles, books, websites, videos, blogs. I read about a guy who was trying to patent a new kind of medical restraint. It was rejected because there was a similar kind of medical restraint used in a movie And the movie counted as prior art, so it was rejected on that basis. There's a big difference between trademark. Trademark examiners just look through trademarks on file. They don't look in the comic. They don't look anywhere else in the world. Patent examiners look everywhere. They're incredibly good at this. They track down things like bloodhounds. So really has to be something new. This is why you really got to search the prior art. It's got to search previous patents and patent applications, but all patents and patent applications are publicly available. And they can be searched from USPTO websites, even applications that failed patent applications, those are still on file. Remember, any resemblance of any publicly available information can result in rejection. I'll mention a celebrity name, Kim Kardashian. Kim Kardashian applied, put up a piece of foundational underwear for a patent. Her patent was initially rejected because her application, her foundational underwear looked too much like an earlier application for foundational underwear, and that one was rejected. So even if your application resembles a failed application, that still counts as prior art because the failed application was public record. Just show you very briefly, we're back here on the good old USPTO website. Now we're going to not test, we're going to patent public search.
John, I think we're still seeing your slides for
I'm
some
sorry.
reason.
Okay.
That's okay.
I'll fix that. There it is. About that.
Nope, still on the slides. I don't know, you might have to stop share and reshare or.
Okay, yeah, I'll do that. Okay. Sorry, folks.
The joys of Zoom.
How about now?
That's looking great.
Yeah, good. This is patent public search. This is brand new this year. They just they had the same patent search for many years until they launched this brand new, completely different searching process, which is much better. And this is patent public search, and I'm just going to put in one of my favorite, paperclip dispenser, for example. I'm putting those words in quotes that'll keep those words together. Paperclip dispenser. And just doing the search. Pop up, I found 53 things. Keep in mind that doesn't mean there's only 53 paperclip dispensers on file. There might be other things that dispense paperclips that don't use that phrase. That's why it's crucial. Like this one is, let's go show this one, for example. Trying to find the one. Musical cake plate. Okay, now you'll notice I'm finding things that aren't terribly appropriate, that aren't terribly important, like musical getting cake plate. What you can do is there are ways to tell it, I don't want to look for a paperclip dispenser just anywhere in the record. I want you to only find things that are in the title. You can do that. You can limit to just the title part. And now everything is a paperclip dispenser. And it's crucial. These are classification codes. Classification codes are assigned, one or more classification codes is assigned to every single patent. And that way, if you get the classification code for a paperclip dispenser, you can do a search on that classification code and you'll find a lot more things. It's just like, for those of you librarians out there, it's just like getting a good subject heading. You get a good subject heading, it helps you find more books on a subject than just looking for random words in the title. As you can see, this is a paperclip dispenser from 1977. Minnesota Mining and Manufacturing. Some of you probably know from looking at it, that means 3M. That's what the 3Ms are. It gives you the abstract and it gives you, look at that, it's public knowledge. There's everything you would need, all the instructions you need to build it. Patent means you are revealing exactly how to build something. Now, if you're concerned about keeping any part of your invention a secret, then patents are not for you, because patents need to reveal everything as a matter of public record. Just you have to be very specific. And there's lots and lots of tricks and bells and whistles to patent public search. I'm not going to show them to you. It takes too much time. I am more than willing to talk about these things all day long. If you contact me at the PTRC, we can show you I can show you how to use it. And there's a lot of great things you can do. Go back here. New share. Can you see that? Searching the prior is vital. Okay. Yeah. Okay. There's also provisional applications. Provisional applications. If you're planning to get a patent, but you're not quite done, need to do some more research or really get the invention squared away, you can also submit what's called a provisional application. A provisional application is just a partial application. It does not include the claims section. The claims section is the most important and technical and most specific part of an application. You leave out the claims, you just have to give a description and some pictures of your invention and information about yourself. Then if you file the provisional, you have 12 months to follow it up with getting a full application out there. It kind of holds your place in line. The patent office is on first to invent, first to file. First to file, not who came up with the idea first, it's who filed it and who passed in their homework first. It's you pass in a provisional and someone else tries to apply for the same thing for a patent, they'll say, oh, nope, sorry, somebody else has a provisional. Yeah, someone else did this and they filed their provisional a year before you did, so their patent supersedes yours. When you once submitted, you can use the phrase patent pending. You ever seen that phrase on something? Patent pending. It means they've submitted either a full application, but also if you submit a provisional, you can put patent pending on there. And I know from reading the literature, potential investors like that phrase. The potential investors say, "Oh, patent pending. Oh, they've already submitted some kind of application. They're really taking this seriously. They've already got a patent application process going. That's good. They're more likely to invest in your product." Also, if you have provisional on file, you can discuss your invention publicly without the public declaration being considered prior art. I don't know if any of you have ever watched Shark Tank, but every time they have an invention on Shark Tank, if I watch it, they say, "Oh, you better have a provisional on file because now you're proclaiming your invention to the world, and that'll count as prior art." But if you already have provisional on file, you can discuss it all you want because I've already got the provisional in the works, so I can talk about it. Do you need a lawyer? No, it's not required, but it's a very complex process. And there complications arise just like with trademarks. Much like poor old Kim Kardashian did, someone challenged her patent had a problem, and they had to go through a very complex process to adjust her patent application so that it wasn't conflicting with that earlier one. And they had to do that. And it's useful for when complications arise. Unlike copyright lawyers, a lawyer who just knows a lot about copyrights, they can just say, they can advertise themselves as a copyright lawyer. A patent lawyer has to pass a specific patent bar exam before you can practice patent law. So it's useful if you see someone advertise as a patent lawyer. Yeah, you can ask them, now, did you actually pass the patent bar exam? Can I see some proof of that? Because they have to do that. Okay, keep in mind, as a PTRC, I cannot recommend a lawyer to you. I can only say there are patent and trademark lawyers in Maine. I know they're out there, and you can choose your own on your own, but I cannot recommend a lawyer to you. That's a big no-no for us. What if you can't afford one? I'm not going to read the whole slide, but there are no-cost legal pro bono assistance available through qualified applicants. There are the patent pro bono. For those of you who don't know, pro bono means free. It means no-cost legal assistance. The patent pro bono program has different geographic areas. We're in the New England area. For some reason, as far as the PTO is concerned, Connecticut's not part of New England. Connecticut's part of New York. So any of you from Connecticut might find that interesting, that Connecticut's not New England all of a sudden. To qualify, you have to send in an application. You have to prove that you're below a certain level of income. I think it's 300% of the poverty rate. Acceptance is not guaranteed. Now, if you do get pro bono legal assistance, you're still paying all the application fees to the patent office, but you're getting free legal assistance, and legal assistance really speeds things up. And studies show that the applicants with lawyers, things go quicker with fewer complications because you have professionals working on it. And the one for New England is New England Patent is through the Arts and Business Council of Greater Boston. I've got their name and their link on there. You can't shop around. If you don't like the New England one, you can't say, okay, I'll just go to the one in New York. You can't do that. If your residence is in Maine, you got to apply to the one in Boston. Now, do you really need a patent? It's expensive. Even if you get pro bono legal help, there are a lot of fees. It takes a long time. It can be 2.5 years. It can be at least 4 years. I've seen patent applications that are like 6 years from beginning to end. And it's very public. If you're thinking your invention is secret or the process is secret, the material is secret, then it's not secret. Patenting is not a way to keep secrets. Patenting is a way to, in an organized fashion, let everybody know exactly what you've got. Keep that in mind. Keep in mind, though, if you do decide to get it, come see us. Come see me, PTRC. I can help you learn how to do that important search. I can give you all kinds of guides. I have guides about patents like stacked around the walls. You can't see them, but there's a whole shelf over there of materials I can just give to people for free. The PTRC is free. I can talk to you in person. We can set up a time. I've helped people remotely from a long way away. The only thing we're allowed to charge for is printing, but we don't. There's a printer right in back of me. The printing is free. The PTRC is in a closed system. It's a very sound retardant room, which is why I'm talking in a loud voice, even though there's a library all the way around me. It's free from prying eyes and ears. There's a printer, so you don't have to worry about if you print something off, someone's going to take it off the public printer. So you got that. You can get assistance from the USPTO. This slide will help you with that. You can call the Inventor Assistance Center at this, and they can answer questions about that, and they can help you with the forms. That's why I put this in bold. Now, they're allowed to assist you with the forms needed and with filling out the forms. I can't do that for you, but they can. A very brief word about copyright. I'm sorry to disappoint you, but copyrights are often grouped together with patents and trademarks. It's understandable. They're all part of intellectual property. My knowledge of copyright is just gleaned by going right to the source. If someone asks me about copyrights, I go to the United States Copyright Office, part of the Library of Congress. I recommend this page. This is their page, copyright.gov. What is copyright? And they have a circular about how to register it. Now about enforcement. If your car is stolen, you call the cops and they catch the thief. Patents or trademarks, if your patent is infringed upon, you pay the legal fees and you bring the matter to court. They do not handle enforcement. They just can provide evidence that you have the patent or have the trademark, but you're in charge of filing a lawyer and doing that. And here's my contact information. That's me. There's my email. That's the phone number. That's my office phone. And there's the mailing address. And thanks for attending. Have a nice day, Trademark.
Well, we do have a bunch of questions in the chat. I'm not sure we'll get to all of them.
I kind of thought there'd be more questions about patents and trademarks there usually are.
Yeah, and some of them might be best handled sort of individually if they're pretty specific. But I did see a couple of folks asking about software programs, algorithms, coding. Yeah. Is that stuff patentable?
Absolutely. Happens all the time. Any of you have, if you go and order a Domino's pizza with their online software, you go to you order your pizza online, it gives the patent number right on the screen. Domino's pizza ordering, and it's got the US patent number. I looked it up, and it's just a patent for the process. You can patent a process, and a computer software program is a process. That's very patentable. Happens a lot. Yeah.
And then Hassam asked about like architectural styles. Like, could you patent an example of a new architectural style of home? Yeah, that would be a design patent. A design patent doesn't need to be something small. I guess the examples I gave were small. I gave the examples of a hood ornament and a font. Yeah, there are design patents for entire buildings. Sure. Frank Lloyd Wright got a lot of design patents for huge skyscrapers. Yeah, those are patentable. Design patentable, sure. Yeah. Great. Then Natalia asks, for a company that does several items, is it better to trademark the name and then use all the items under the name, or patent each item? Sort of what's the relationship there?
Well, if you're selling involves trademarks. Trademarks is an act of commerce. A patent doesn't necessarily be something really involved in commerce. There are plenty of people who have design patents that they're, well, like a design patent on a building. That's not really, he's not like doing mass production of the building. It's just a design patent on one building that prevents anybody from copying that building style. But if you're just having a bunch of different products under one name, that's trademark territory as far as I'm concerned. Plenty of places. You don't have to have one trademark for one product. I mean, I've been picking on snack cakes a lot, but you can have one trademark. I can't remember. I think it's Lentimans. Yeah, I think it's something like that at the grocery stores where it's one trademark, but they make cakes and pies and individual snack cakes and donuts, but they all have the same trademark on the box.
Great. And Suzanne asked, would you patent a recipe or just trademark the brand?
Excellent, and very common question. Recipes are incredibly unlikely to be patented because you got to pass that non-obvious thing. If you're thinking about making lemonade, he said, my lemonade's going to have cinnamon in it. He said, well, you can't prove that someone in the history of the planet has put cinnamon in their lemonade. That's too obvious. It's an obvious thing. It's obvious to anybody. Anybody who is a professional beverage maker. Is too obvious for them. That's why the patented recipes are the ones that are happening in an industrial scale, like for the mass production of a beverage, a mass production of a baked good. The ones involving food are the ones that patent a new kind of machine that bakes bread automatically, or a new kind of process that makes a certain kind of dough. I think, to my uninformed opinion, uninformed about copyright, it seems like the only way you could put a stamp on a recipe would be if you put it in a book or a publication and slap your copyright on it. You can be copyrighted.
Actually, my sister works in cookbooks, and you can't copyright a recipe itself. They're kind of a unique animal. Material around it, if you write a little article that goes with it, that can be copywritten, but the recipe itself, they're special.
I didn't know that. I've only focused on recipes. You can see that I'm just not the person around here who knows the most about copyright. There are other librarians working here who have more experience with copyright research than I do. And people who have done research on that. And I certainly get questions all the time about patenting or trademarking recipes. I did not know that about copyrights. Thank you, Hannah.
Yep.
I'm learning
for you. So there's a couple questions kind of related to your work at the PTRC. One is, are there any other branches of the PTRC, like closer to the Portland area, like at USM?
There are not.
I am
the only PTRC in the state. And nice. I admit, I love working here, but I admit if you were going to, if before it was founded, if someone asked me, where should I put the PTRC? I said, well, obviously you should put it in the largest city in the state. But I wasn't in the PTRC was already here when I got here. But no, that's why I want to emphasize that I can help you remotely. But there's no other PTRC in the state that you can walk into besides mine. But there's a PTRC. There are PTRCs throughout the country. And the directory of them is on the PTO website.
That's great. That kind of relates to this next question, which is, can you give advice for people outside of Maine? Like someone I think is writing in from Florida. No,
I've got a gag order. I cannot. I thought you meant like recommend lawyers.
No, just like, you say you can work with folks remotely. Do you have limitations on that? I've
helped people from New Hampshire and Massachusetts. No reason I can't do it for Florida as well. Sure. I welcome anybody. Anybody wants to set up a remote thing or talk to me on the phone? Sure. No problem.
Excellent. All right. So there's, again, a couple more specific questions that I'm going to just encourage folks to follow up with you directly. And sure. You've got your contact information in the slides, which we'll send out. But there's one other question from Martin that's a little more general. Is there a specific function on tests that helps with foreign language translations to your word that you're trying to trademark? Okay.
There
Great.
is, yes, there is.
And I
a
bet you
function for
could
that.
show folks more about that.
I can certainly can. There is a specific, there's a specific search tag and a process of looking for translation. That's like the example I gave about the French word for sheep. They take that in seriously, especially if, now the example I gave about the French word for sheep and the English word for sheep is especially important if you're thinking about trademarking a product that's going to be sold in a place that where there's a large French speaking population, which we know there's some of that in Maine. Certainly, if you're trademarking something you're going to sell in Lewiston, you got to think about English and French translation things. And certainly if you're selling in Los Angeles or Florida, you want to check Spanish, English and Spanish meanings of a particular word. But Tess is there's ways to do translation stuff. Sure.
Great. Well, I think we should wrap up unless anyone else has a burning question we need to answer right now. We can wrap up, and I just encourage you all to follow up with John with your specific
Absolutely.
questions.
And I'll send a PDF to Hannah very soon here, and she can pass on the PDF of all these slides.
Yep, and I'll send out the recording as well.
Great.
So thanks to everybody for joining us today.
Okay.
And
Later,
have
guys.
a good afternoon.